How are you doing? Hope you're all doing well. Is this the first time that you've jumped on one of my calls? It would be good to know. Have you been before? Good afternoon. Thanks for chatting to me in the chat box. It's always nice to hear from you guys. Good afternoon, SK. It's good to see you here. Let me know where you're up to in the process as well, because I'm assuming that if you've jumped on here, that you're going through a divorce or that you are thinking about it. And it's always good to know where you're up to, how far you've got, so that I can tailor what I'm talking about specifically to your situation. If you've been before, you'll know how this works. But if it's your first session with me on a Wednesday, let me just take you through the way these work. So I talk for about 30 minutes on whatever subject we're covering. I ask you to put your questions and comments in the chat box. And then usually I come to them at the end and answer anything that's come up for you, or about obviously the subject that we're talking about, but anything else as well. So the session is about 45 minutes. Sometimes I go a bit over on what I'm talking about, but I try and keep it to around that. So hopefully I'll be able to do that today, because obviously it takes up a lot of your time as well. So today is all about maintenance. And I haven't done this talk before, so this is a new one, just because I think it's an important topic. Lots of people talk about maintenance. They assume that, maintenance would be included, or there's only one type of maintenance. And I think it's important for you to understand how maintenance works. I recently had somebody who I spoke to who had an amazing maintenance agreement in her consent order, but unfortunately, it hadn't been written well, or it hadn't been explained to her properly what she was signing, and she couldn't enforce this maintenance agreement that she had. And actually, the rest of the asset split didn't work well without that maintenance agreement. And that's why it's really important that you understand maintenance. Obviously, I'll talk through it generally. Do ask your questions as I'm talking through, because there may be something specific to your situation that you need to know a bit about. And that's why maintenance is so important to cover. And a little bit about me as well, because maybe if this is your first session, you might not know who I am. My name is Bhavna Radia. I am a former family lawyer, and family law is all I've really ever done. I was in practice for many years, helping families through divorce proceedings, financial, children, domestic abuse, injunctions, adoption, all sorts of different elements of family proceedings that I was involved with. And I was doing this until I went through my divorce, and I kind of felt like the work that I was doing, although it was good work, it felt a bit empty when you go through something yourself and suddenly you understand how your clients really feel, not just what you think they're feeling. And since my divorce, I was back in practice again, and gave up working in practice to work a bit differently with people, which I'll talk a little bit about at the end. But when I went through my divorce, I didn't have the funds. If I had to pay for a lawyer, I think I would have struggled. I know I would have struggled. I didn't have the money to be able to afford legal fees. Luckily, I was able to do my divorce myself, write all the documents, go through the process. I didn't need help with that, so I was fine. And it made me wonder about people that didn't have that knowledge, who couldn't access help either. How could we bring something that was more affordable, something that they could manage themselves, so that they could get through this process well-informed, empowered, and with clarity? And I will talk about that, as I said, at the end. I really want to sort of get on with the subject, give you the information that you need to make the best decisions for yourself. So let me just share my screen with you. Do let me know if you can see this. Okay, hopefully it does share. Fine, that looks like it's sharing. And I'll keep an eye on the chat box as well. So if you've got any questions for me, I can keep an eye on that. So I already mentioned why we are talking about maintenance, because it is a practical topic that you should know about. Lots of people are confused about how maintenance works, what it could be. And it's also quite frightening when you're going through a divorce if you are worried about how you're going to make ends meet. So this gives you an idea of what support you could get, what support you might have to pay if you are the person that would have to pay maintenance. There's different areas that I'll be covering today. And actually, maybe I should move on to the introduction so you can see that. So I'll be covering child maintenance and what that means, what happens with other child expenses, what about education expenses, and something called spousal maintenance as well, because these are all elements of maintaining children, maintaining the other person, and looking at education costs as well. So to start off with, let's have a chat through child maintenance. How does this work? So child maintenance is a legal obligation to support your child financially after you have separated, after the parents have separated, or after divorce even. And it's to make sure that children continue to receive that financial support from both parents, despite the family dynamics changing. So often in situations, one person is earning more than the other. Often in a situation, it may be that one person is doing more of the care of the children than the other. And so child maintenance is based on one parent being the resident parent, and this is really important to know. One person is the resident parent and one person is the non-resident parent. So what does this mean? This is where one parent has the child or children for more time than the other. And we're usually looking at overnight stays. So if you have an arrangement for your children where, say, you're doing 5 days and the other parent does 2 days every week, then you doing more time with the children makes you the resident parent. If you've got an arrangement where you've got an every other weekend arrangement, so one parent has the children every other weekend, they become non-resident and the other parent becomes a resident parent. But what's also important to note is that if you are doing equal time with your children, if you have an arrangement where you've got 1 week on and 1 week off, over a 4-week period, you're both doing the same amount of time. You might have a 4-3 arrangement. So in week 1, you've got 4 days, the other parent has got 3 days. In week 2, you've got 3 days, the other parent has got 4 days. Over a 4-week period, you've got exactly the same amount of time. And you may have a variation on this. People do a 2-2-3 arrangement, but essentially you've both got the same amount of time over a 4-week period. If that is the case, then both of you are the resident parent. There's no non-resident parent because you've both got the same amount of time. And child maintenance wouldn't be relevant. So as long as you've got the same amount of time with your children, neither of you gets child maintenance. If there is a slight difference in that and one parent has more overnight stays than the other, then child maintenance does come into play. It's important to know that. Often parents will come to their own agreement on maintenance. That's what we see mostly. And you can base this on the child maintenance calculator, which I'll go through a little bit with you now. The child maintenance calculator will give you the basic legal obligation. Sometimes parents want to agree something that isn't the basic legal obligation, and we can again talk about what that could look like. It might be that, say, for example, the child maintenance calculator says that you would get, as the resident parent, you would get £500 a month, that parent might say, well, I'll give you £800 a month as child maintenance. And that is perfectly fine to do. There's lots of ways of structuring child maintenance, which I'll talk about a bit. But if we just look at the legal obligation, the basic calculation to start with, that is done by the Child Maintenance Service. And in the UK, there is a formula that is used for basic child maintenance. You can calculate your own child maintenance based on the child maintenance calculator. And I'll give you some information about where you can find this in the chat box as well. So there is child maintenance calculator. You can Google it. It will come up with a way for you to calculate your child maintenance, and it can email you the calculation so both of you can see that. And the calculation is primarily based on gross weekly income of the non-resident or paying parent. So the gross weekly income of the non-resident parent, it's also based on the number of children that you have, that the non-resident parent is paying towards, and the number of overnight stays that that parent has. So 3 different elements that are included. Gross weekly income, it's important to know what that means. It's income before tax and national insurance, but after pension contributions. So again, really important to know, it's not just gross income, it's gross income, which is before income tax and before national insurance, but after they have paid a certain amount towards their pension. The income data can be sourced from the latest HMRC records. So the Child Maintenance Service can get information from HMRC about the non-resident parent's income. The kind of income that is included is salary and wages, so anything paid as PAYE, bonuses and commission, self-employed earnings as well. So you might have a mix of PAYE and self-employed income. So we would look at your payslips. We would also look at self-assessments that you have completed for income tax. Rental income, usually this is included in your self-assessment as income that isn't PAYE, but you've received. Pension income and any other income, any other taxable income that you receive would be included in this gross weekly income. So it is everything that you receive. So that's how the weekly income is calculated. Just so you know that maintenance is payable until a child is 20, as long as they are in full-time, non-advanced education. So that is A-levels, BTECs, NVQs, anything like that, but not including university, so not including undergraduate or higher. As soon as they move on to undergraduate or higher, then maintenance stops. So usually children go into university at 18 or 19, depending on their situation. So that's when it would stop. Okay. So coming back to income, there is a high income cap, which you need to be aware of. So if you are doing the child maintenance calculator and trying to work out what the maintenance should be, bear in mind that that calculator has a cap of £3,000 per week. So if the non-resident parent is earning gross income after pension contributions of more than £3,000 per week, you need to look at a different calculation because that is capped. So what you would need to do if the non-resident parent, the paying parent, is getting approximately £156,000 per year gross, then you would need to apply to the court for top-up maintenance. So there is 2 different elements of maintenance, which makes it a little bit confusing, but it's important to know that. So if the non-resident parent is earning more than £156,000, don't just use the CMS calculation, the Child Maintenance Service calculator. to calculate maintenance, because that will give you the basic, and there should be a top up on that as well. So you can apply to the child maintenance service for them to do a calculation for you based on your on the non-resident parent's income, and they may say we cap it at 3,000. If the non-resident parent is getting, say, £200,000 income per year, then you may need to get a top up, and that top up would be you applying to the court for the court to work out what it should be. Yes, it is a maintenance order for the top-up maintenance. So the court would have a look at the person's income, what the child maintenance calculator says, and then what should be the additional maintenance on top of it. And what they take into account is based on lifestyle, based on the needs of the children, standard of living enjoyed during the marriage, educational costs, including private schooling, and other expenses as well. So you might need a top up of your maintenance depending on lifestyle. So for example, if that person is earning 250,000, 300,000 pounds a year, then the cap means that you're not getting sufficient child maintenance, because it's likely that the standard of living you enjoyed during your marriage, to keep you both in the same, not the same standard of living as you had during your marriage, but equal to each other, then your maintenance payment is not going to be sufficient. So you might need a top up. You might just agree a top up and you put that in your agreement. And I'll tell you a little bit about how to make this legally binding and what you need to consider. So you do need to consider whether you need this top-up maintenance, whether you are entitled to this top-up maintenance. So do bear that in mind. Time spent with the child is relevant. And so depending on how much time the non-resident parent does spend with the child, there is a certain amount of reduction in the child maintenance. It's quite a complicated formula, so I won't go into it in a lot of detail, but you can put all of this information in a child maintenance calculator and you would be told what the amount is. But do bear in mind that there is a cap on the calculator as well. If you find out that that your ex-husband or wife has additional income, if they're the paying parent, that isn't covered by PAYE or self-assessment, then you do need to let the child maintenance service know. So it might be that you're asking the child maintenance service to come up with a calculation for you, and you believe that not all income has been given to the child maintenance service. It may be that there's additional income that hasn't been included, or if you're unsure about the paying parent's income, what they have included, you can ask the child maintenance service to do a variation. What you would do is provide information to the child maintenance service of any income that potentially the paying parent has left out, and they will look at the calculation they've made and may vary the child maintenance calculation. So it's important to know that that is possible to do. If you make an application to the child maintenance service because you would like them to make a calculation, do know that if there's something that's been missed out, something you're unsure of, then you can contact them, make this variation, explain the income that you believe that person is receiving and from where, and they can look into that and potentially vary the calculation. So how do you make this calculation to the child maintenance service? Because you might decide that rather than agreeing it yourself, you want to make an application to the child maintenance service for them to tell you what it should be that you should receive if you are the receiving parent. And it might be that you make this application because the other parent won't tell you what their income is. They won't be honest. They won't give you pay slips, their P60, their self-assessment. which is what you need to work out what their income is. And if it is not possible for you to obtain this information, you might not have a choice but to make this application to the Child Maintenance Service. It may be that you know what they earn, you've seen the evidence, but they're refusing to adhere to the child maintenance calculation that you have done yourself online. It might be that one month they pay you £500, the next month they pay you £100 because they say they haven't got the money. They might pay £400 the following month, and you're thinking, I don't know where I am. There's no stability here. The calculator says it should be £500, but he's paying or she's paying all different amounts, and I can't manage this way. And so what you want to do is make a child maintenance application. To do that, you would contact the Child Maintenance Service, and you can do that by telephone. You can do that online. So if you search for make a child maintenance application online, it will come up with the .gov.uk website, and you can do it online. It's really quick and easy. It doesn't take too much time. Or you can complete a paper application, but most people don't do that, and you can find the paper application online. So you fill in this form, whether it's online, whether it's on the telephone, and you give all the information. Now, child maintenance, if you are the person receiving child maintenance is not based on your income. So they're not interested in how much you earn. It's all to do with the other person. So the Child Maintenance Service would contact the other parent. They would notify them that you've made this application, and they will ask for the financial information that they need. They would check that person's financial information through HMRC records. If the other person doesn't contact them, doesn't want to provide information, they can still check the details through HMRC. So if that person doesn't respond, it will still be, there still will be a calculation made based on previous tax records, based on employment data of how much they are paying in tax, NI, how much they're earning. So once the CMS have done this, once they know what the other person is earning, they will calculate the child maintenance amount based on that paying parent's gross income and the number of children and how many overnight stays that person has. Then they will inform you of what the amount should be every month and when it should start. They will also let you know that if you don't receive the amount, that you should let them know. So there's two ways to arrange payments. One is direct pay, and this is where the Child Maintenance Service tells you this is how much they have to pay, and that person just pays it directly to you. There is no nothing going through the Child Maintenance Service. You just receive the payment every month for the amount that the non-resident parent has been told to pay you, and on the date that they have been told to pay you. There's no fees. You just carry on with that, receiving that money or making that payment according to the schedule that you've been told. If you think that person is not going to pay, if you think that they're going to pay different amounts every month, depending on their affordability or what they've spent or what they tell you they can afford, then it might be better to use the collect and pay service that the Child Maintenance Service has. This is where the Child Maintenance Service collects the payments from the paying parent and forwards them to the receiving parent. So there is nobody else involved. The payments are made to the CMS and they pay the money out as well. There is some charges for this. The parent paying child maintenance would have to pay an additional 20% collection fee, and the receiving parent has to pay 4% for this collection. So there are payments that has to be made. But if you believe that the non-resident parent is going to mess around with payments, then sometimes if you're the receiving parent, it's better just to pay the 4% and get the payment in. So once the payments are set up, whether you are doing direct pay, whether you're doing collect and pay, once this is set up, the CMS will regularly review the parents' income, the paying parents' income. You don't have to do it in the future. Usually annually, they will check the paying parents' income and tell you if your child maintenance amount should be different, which is quite useful so that you don't need to do this yearly. They will also want to know if that person doesn't pay. So if you have a month where payment is missed or you get a lower amount, you can let the child maintenance service know and they will take action themselves if payments are missed. So that person will then go into arrears and they will write to them to say, you're now in arrears, you need to make up this month's payment, plus obviously continue paying your monthly amount. If the payments continue to be missed, they can enforce it. So they can deduct the maintenance payments from earnings. So they can deduct it directly from the person's salary or wages. They can get a liability order where that means where the CMS can recover arrears through bailiffs. And then court enforcement. So if the person still doesn't manage to pay the arrears and the ongoing amount, then the CMS will start court proceedings, maybe get an order for sale of a property. They could put a charge on a property. They could even ask for imprisonment in extreme cases if that person is absolutely refusing to make these payments. If at any point you disagree with the decision, then and you've applied for a variation and no variation has been made, or the variation you believe is incorrect, you still have that option of appealing. So you have to do it within 30 days of the decision, and they have to consider it. If you're still dissatisfied, then you can go to a tribunal. Most people don't take it that far, but that is an option. So the process of the child maintenance service dealing with this application, telling you how much the maintenance should be and the first payment coming out is usually about 4 weeks. I've seen this happen quite quickly. Sometimes they do it much quicker. So it really depends, but it can be longer if either of you request a variation and then there's an appeal, but generally as it goes through, it's about 4 weeks. So that's a bit of information around how that element works. But should you have a private agreement, or would it be better for you to apply to child maintenance through this application process that I've mentioned? Some parents do prefer a private agreement. They don't want to get an authority involved. They don't want to get an organization involved. And that is okay. It gives you flexibility. So it could be an amount that you've both agreed, might be higher than the basic child maintenance agreement. So you might be happy with this. You ideally want to put it in writing if you have got an agreement that is not based via the child maintenance service. It's an agreement that you've put together yourselves. You would want it in your consent order. So this is a financial agreement that you have prepared based on your assets that you have. You would want to put it in there so it becomes a court order. So at least you know that it could be enforceable if that person didn't pay. But also both parties are aware of what the child maintenance amount should be. It's also wise to review and update your agreement. So whatever you put into the court order is only valid for a year. Really important to know that in your consent order, your financial agreement that you reach, which is formalized, anything you put down as a private agreement for child maintenance, you can only enforce it for 1 year. After that, you would need to go to the child maintenance service for a calculation to be done. So if you are putting a very high amount of child maintenance in that is above what the CMS would have calculated, then it's better to write your consent order slightly differently so that we protect you. So like the lady I mentioned, she called me last week, and she'd put this, that there was this high amount for child maintenance in the consent order. It wasn't enforceable anymore because a year had passed, and her CMS calculation was coming down really low, and she had based her whole asset split on this high maintenance. So she hadn't been advised correctly, and that's really important to know. So why would you use the child maintenance service to give you a calculation? So once you have a calculation, it's automatically checked every year. You don't have to do it. You don't have to ask the other person. If the paying parent misses payments, they would also need to make up arrears. If you've got a private arrangement, that wouldn't be the case. They wouldn't have to make arrears. Arrears would only come into play from the date of application to the child maintenance service. You can't really enforce a private arrangement yourself. You couldn't say, I'm going to get bailiffs to come and get the, take things from your house if you don't make payment, but the CMS can. So sometimes it's better, even if you've agreed something, to do it formally through the CMS. So you've got it in writing, that calculation's made. If they don't pay, you can let the CMS know. If you need to enforce it by getting money straight out of their salary, the CMS can organize that for you. If they are up and down with making payments, you could use their payment service. So that way they can actually collect and pay you the money. So my preference is actually doing it through the child maintenance service. What isn't covered by child maintenance? So usually the child maintenance covers basic child maintenance. Sometimes it does, there may be additional expenses that you still can't afford if you are the resident parent. Things like private healthcare, for example. You may have your children on a private healthcare plan, and you might want to continue that. There may be extracurricular activities such as sports, music, other clubs that the child attends, which you can't afford to pay even though you are getting child maintenance. Educational materials and equipment. There may be school trips, lunches, travel expenses for traveling to school, for example, that may be additional to child maintenance. So really good idea to agree these expenses if you are looking at these expenses as additional. The non-resident parent doesn't have to agree anything here. Their legal obligation is the basic child maintenance calculation. But just so the children don't suffer and have to reduce all of these extras that they are getting, you might want to agree what happens with these extracurricular, these extra children's expenses. So it's really important to agree this up front and incorporate this into your financial agreement consent order. Really important to consider that. There's the whole element of private school fees. If your children go to a private school, do you want this to continue? If you do, usually the basic child maintenance won't cover this. So you need to reach an agreement about who's going to pay the private school fees. Will they be shared between you? What sort of share would you both pay? Is it going to be the parent with the higher income would pay 70% and the other person would pay 30%? How will it work? This also needs to be, what you need to consider is what happens if one parent's financial situation changes and they can no longer afford to pay the private school fees. And all of this needs to be noted down in a financial agreement or the consent order. If it's in your consent order, then it can be enforced. So really important to include that. This is slightly outside of maintenance, but lots of people forget this. So it's really important to make sure you make a note and include it in your agreement. The other thing that lots of people talk about is university contributions. So this basic legal obligation on child maintenance will cease when your child finishes full-time education, such as A-levels, BTEC, etc. But it doesn't cover university costs. So when if your child takes that step and is going to university to do an undergraduate education, then what will you do about the expenses of that? So you can include this in your divorce settlement as well. You need to cover tuition fees. Will they use the loan to cover tuition fees? Will you both be contributing to that? What will you do for the child's accommodation fees, the living expenses, maintenance, any books they need, any other equipment they may need for their university course, travel to university, food, etc. How will all this be paid? What can you put in your agreement to cover this? Will you just ignore it and say, well, depending on our situation, we will decide at the time, which is perfectly fine, and not include it in an agreement? Would you prefer to say that both of you will contribute a reasonable amount depending on the child's expenses at that time? Or would you want to put down that the parent with the higher income will contribute in total to the child's expenses minus tuition fees, for example? So what is your situation? What would you prefer to put down? You can have something written in your agreement around the costs of university. So think about that as well. And then there's this element of spousal maintenance. So it's really important to look at spousal maintenance as well. It's now not as common as it used to be, where, parents had their roles. One person didn't work and one person did. In those situations, a person who doesn't work maybe hasn't worked for 30 years. And so therefore their income capacity, their earning capacity is almost non-existent or very, very low. And so in those sort of situations, spousal maintenance agreement might be necessary. So a spousal maintenance agreement or order, it's there to provide financial support to a spouse who may be at an economic disadvantage following divorce. And it can only be done on a divorce, not on separation. It aims to help the financially weaker party maintain a reasonable standard of living. So it's usually limited. It's not sort of spousal maintenance for life, which we used to see many, many years ago. It's not spousal maintenance for 15 years. Usually it's limited to allow the spouse to increase their income, or for the children to start school, so the financially weaker party can work full time or take more hours. And so therefore their income could be increased. So sometimes it's based on a parent that maybe is a stay-at-home parent or works part-time so that they could look after children. And depending on how much they earn, depending on how much the other person earns, you would look at a spousal maintenance order. So it can be regular ongoing payments, often monthly, to help that person survive financially, really. Even though they may be getting child maintenance, they may also be getting top-up payments towards children's expenses, etc. Spousal maintenance may still be necessary. It might be a fixed term payment, so support for a limited period to help one person get to financial independence. It might be that you look at a lump sum, a one-off lump sum payment that ends all financial ties. But what this lump sum is almost taking this spousal maintenance amount and turning it into a lump sum rather than paying monthly. And sometimes people prefer that, so that a lump sum has been given and that is used for these extra top-up payments that are needed. It could be invested also to bring income to help you manage your monthly expenses. So how is this worked out? So the kind of things that the court would look at if you were in court proceedings when thinking about spousal maintenance, it would be the length of the marriage, the age and health of the parties. So if the marriage has been 30 years and that person worked part-time, then it's unlikely that they would earn too much more. So it may be that they need spousal maintenance for a longer period. age of the parties. So if one person is nearing retirement and their income is likely to be reduced, then maybe spousal maintenance needs to be lower as well. Health might be a consideration if one person cannot work from a health point of view. Financial needs and obligations. And what this means is looking at both of your income and expenditure, because one of you may have a deficit and the other person may have a surplus. So what we are looking at is how can we get rid of that deficit and what surplus is available from the other person to help with that. So the standard of living. So what the court is aiming to do is that both of you have a similar standard of living after your divorce and separation. So how can we achieve that? So, and contributions by both parties. So if one person has given up working full-time or given up a huge income to stay at home, do more of the childcare and has taken a part-time job, say for 10 years, it might be hard for them to get back into that industry. And so therefore that needs to be taken into account. Spousal maintenance may be in your order, maybe in your agreement, but sometimes there's a change of circumstances and your spousal maintenance needs to change as well. So that's the disadvantage of spousal maintenance. So say, for example, you're the person that receives this spousal maintenance amount. If you remarry, then you do not get the monthly amount. So if, say, for example, it was written in the order that you get this amount for 10 years, the £1,000 a month for 10 years. If you remarry in year 5, you will not get this amount. If you cohabit with a new partner, you will not get this amount. So it limits you from that point of view. If the person paying spousal maintenance loses their job and you take them to court to get this spousal maintenance from them, the court will look at their situation and say they're not working, they can't pay it now. If and when they get a job, they will need to make payments and they could assess that. So if your financial situation changes and you're the paying person, then it may be that you can't afford it anymore. If the person paying spousal maintenance passes away, then you would not get these payments anymore. So you have to think about whether a lump sum would be better in that situation, because spousal maintenance can be terminated. So just bear that in mind as well. So I know that we've probably gone over time already because I've covered so much. So conclusion, there is a difference between child maintenance and spousal maintenance. Child maintenance, we have a formula that we can use for basic legal obligation, although you can get a higher child maintenance amount than the basic child maintenance service formula. Spousal maintenance has limitations as well, because if that person loses their job, you may not get spousal maintenance or child maintenance. So bear that in mind. And that child maintenance written in a consent order is only enforceable for 1 year. So you have to be very careful how you reach these agreements, because there's lots of things that could trip you up when you are looking at, say you need £1,500 a month and it's made up of spousal maintenance and child maintenance. How are you going to write this in to protect yourself? So there's different ways of doing that. Plan ahead for additional expenses. Think about how things are going to change for you, change for the children, so that you don't get yourself into difficulties financially. But make sure everything is in writing. Usually the safest way is a financial consent order, or an order from the court, or a calculation from the child maintenance service as well. So I'll move on, because I know we're quite out of time. So the different ways to work with me, as I mentioned, I have a fixed fee program, which is for 6 months, and we work intensively through those 6 months, and it can go on for longer if you need, so that we are moving things forward. And during that time, I'm not acting as your lawyer. I am guiding you, supporting you, advising you, giving you ideas of what to do next, telling you your next steps, reviewing correspondence, helping you decide what your financial agreement could be, giving you all the options, helping you decide how to formalize, say, maintenance, how to put a lump sum in the agreement, all the different elements of your assets as well as maintenance that needs to go in your agreement, looking at parenting plans, everything that you need with a fixed fee. So that is under a fixed fee, so you are not worried about your legal costs going up. And we cover as much as we can in the 6 months, but you can continue working with me in that way if you need to as well. So that's one way you can work with me, which is cost effective. We cover everything. Even if you end up in court proceedings, we are still working together on that. You could work with me ad hoc on an hourly rate if you prefer. It might be that I give you some things to do, you go and do them. When you are at a certain position, you come back, we have another call, and I help you move forward. So that's possible as well, and it's on time spent. And then I do have my amicable divorce service, which I don't take on a lot of clients for, but I work with couples through this process to help them from start to finish, all the way through, so that they can work together amicably in a fair way to work through this process. So I can definitely work through on these different ways. If you would like to know more about how to work with me, what is best for you, then feel free to book a call with me. We can have a chat and make sure we find the right way to work together, because it is important, depending on your situation, that I guide you the right way. So it may be that an hourly rate is better. It may be that actually working together intensely would be better for you on a fixed fee. So we can work that through. Nelmar's put a link to book a call, so feel free to book a call and we can have a chat. I have a book as well, The Divorce Planner, which is there to help you take action, to help you move things along yourself. It guides and gives you information on how to do certain things yourself. There's downloadable resources as well, and you can actually fill in the information in the book or download the worksheets to fill in the information as well. So really useful, and it's there to help you save money as well. There's lots of different ways to get in contact as well, different ways that you can see the things that I'm sharing. The YouTube channel is there as well. Subscribe to that and you'll always get updates and the new things that I'm sharing. I've got lots coming up on that. You can email me, Instagram and Facebook as well. So lots of ways of getting in touch as well. So hopefully that just means that you can get in touch with me if you need to. So let's have a look at what you've been asking. I did see a few questions there. We have our first financial hearing on Monday. He hasn't filed his Form E and has said that he was not aware of the court dates. I've emailed the court asking them to consider making appropriate directions. Should I do anything else? I'm scared of attending the hearing. Any advice? How long will they give him in the direction to produce the Form E? Will there be another first hearing? Lots of questions there. And do reach out to me, to the person who sent that, and we could maybe have a chat as well. So the first thing is, if he hasn't filed his Form E, then depending on your situation, you could attend the court hearing. I don't know if he will attend or not, but you should attend. It's always better to attend. The court expects you to attend, but it is just you, the judge, and him in the courtroom if he doesn't bring legal representation, and you don't bring legal representation. You can have somebody there, but it's likely to be quite predictable what will happen. So it's up to you as to whether you take somebody. The options are taking a direct access barrister or taking a Mackenzie friend. A direct access barrister can talk for you. A Mackenzie friend could be there to support you, but they can't talk for you. So you would need to talk. But the way of getting rid of some of the fears that you might have is filing a position statement before the hearing. And that sets out everything that you would tell the court at the hearing, telling the court all about your position. That the Form E hasn't been filed. This is what the situation is. That he's saying that he wasn't aware of the court hearing, so you're not sure he's going to attend or not. He maybe wasn't sure that he had to file a Form E, whatever the position is, and what you expect the court to do, so that you limit how much you need to say. The court can read that and know everything. And there is a format for doing that. So that might help you. Do I need to do anything else? So I would do file your Form E with the court, not necessarily with your ex. You shouldn't file it with your ex if they're not filing it with you. You should just file it with the court so you're compliant. Follow all the directions that the court gave you. So the court may have given you lots of documents that you needed to file. Some of them you won't be able to file because you haven't seen his Form E. Some of them you will be able to file. There'll be lots of things you can file. So follow the directions so you're not in breach. The court will give your ex another opportunity to file the Form E, and there will be another first hearing, so don't worry about that. The court is likely to say, we need to have another directions hearing to see where you're up to. But I think it might be important that you just message me or email me, and I'll talk you through some of that. But I hope that was helpful. Tried to cover as much as I could in the time we've got. So I haven't yet started the divorce process, but that's the next steps. I have a hearing tomorrow, reoccupation order, and I know he will contest it. Is your hearing a without notice hearing? Maybe the other person isn't aware of the hearing. If they are, then they will contest it, most likely. I'm getting mentally stronger each day and will fight for my rights, absolutely. Early this month, the court granted a non-mol. Okay, so you've got the non-molestation order, you just need the occupation order. I've been advised today that I need to make a child maintenance application, but if I'm honest, I feel like I don't want anything from the father because he will forever make me feel like a bad mother for asking for support. Well, it's a legal obligation, number one. If you don't need the money, put it in the child's bank account, use it for expenses for them, use it as savings for them. It's an entitlement that you have for your children. So from that point of view, you could take that and just have it as savings for the children. You don't need to worry about what the other person says. They will have lots to say, and it's a legal right. So you need to focus on you and you need to focus on the children. So around the occupation order, if he contests it, you need to show that that there is a balance of harm test. That number one, if an occupation order isn't granted, that would be harmful for you and the children. Number two, that he's got somewhere to go. So at least, you know, if an occupation order is granted and he cannot return to the family home, there is somewhere else for him to live as well. And that he has the financial resources to rent, for example, as well. And you can, I don't know if you did, but you can ask for mortgage payments to be made by the other person if you financially can't afford them, or for them to contribute to the mortgage costs while you're living there as well. So I hope that answers your question. The process has started. Husband has received the first application, but yet to accept it. He made it clear that he will not pay our child maintenance, even though I will be with him more than as the resident parent. He said, I want the divorce and I have to deal with the consequences, but he doesn't want to pay me to live comfortably, which he sees as the child maintenance payments. He is only willing to pay for trips, clothes, and things the child needs and wants a 50-50 split for this. So when you say 50-50 split for this, I imagine you're talking about the trips, clothes, and extracurricular activities. He'll pay half. If you are the resident parent, then you have a legal entitlement, which you might say you don't want to push right now. You can make a child maintenance application to the CMS at any point. It doesn't have to be now. You could, in your financial agreement, not include it, and then later on make that application. It is a legal entitlement because you will have more expenses than the other person. How you are sharing time with the children will be taken into account. So if it's almost 50-50, it's likely that your child maintenance will be limited because of that. But it is a legal right, and you may want to push that later on. You don't have to push it today. But do touch base with me. I do know obviously who you are. So touch base with me and we can discuss that. I have generally always worked. We have 3 kids primary school age. However, I've had to leave 2 of my jobs as caring for the children, and working has been too much. Will the courts consider my earning capacity in calculating maintenance? I am currently out of work from December. So the child maintenance service would be assessing your child maintenance initially, and your earnings are not relevant. So it's all about the other person's gross income, nothing to do with how much you earn. You could be earning £500,000 a year and still be entitled to child maintenance, even if you're earning more. So your earning capacity is not taken into account when we're looking at child maintenance through the child maintenance service. If you're entitled to top-up maintenance because that person earns more than £3,000 a week, £156,000 a year, then you would need to go to court for that. And if you're going to court, the court will consider all financial circumstances, how much you earn, how much they earn, what happens to your standard of living, whether you have a deficit, whether you've got a surplus. So it may be that there needs to be a top-up maintenance calculation included. If you're looking at how assets are split, how liabilities are split, earning capacity is relevant there as well. If you have a lower earning capacity than the other person, then that is relevant on the split of the assets and liability as well. So that needs to be taken into account. So I'll answer a couple of more questions. I can see that there's a few coming in now. I've got another direct message. My ex-partner left me with our 2 children and initially did not allow me to see them for nearly 2 years. So your ex-partner left and the 2 children left as well. I eventually gained access through a court order which allowed me to see my children every Sunday. The arrangement went smoothly for approximately 3 months. However, one day my ex-partner abandoned the children and has not returned or made any contact for the past year. Since then, I've been solely responsible. Given the circumstances, I'm considering applying to vary the existing court order to reflect the current reality and provide more stability for the children. Well, you don't necessarily need to do that. You can, if you are looking after the children, you are the main carer, you are the resident parent. And the child maintenance, if you make a child maintenance application, that would reflect that you are the resident parent, that you are solely caring for them. So you don't necessarily need to change the existing court order. It's out of date, but the current reality is different. I want to know if I have grounds to seek a formal change in the court order. She is on benefits. Can I still ask for court child maintenance from her? So if you want to vary a court order, you would need to fill in the appropriate forms. You would need to apply to the court, and you can either do it by consent if your ex-partner agrees. If they say, yes, I'm happy to vary the court order, you can apply on a C-100 saying that you want to apply for an order by consent. If they won't consent, you would need to apply for the court to have a hearing to vary that existing court order. He or she may contest it as well. So then it would turn into more court hearings depending on the situation. So you don't have to change it if you feel like you want to or you need to for various reasons, then you can. If you are self-representing, how do you file the mortgage valuation to the courts and forms? I had a solicitor, but I've run out of money. Okay, so depending on what you mean, I mean, you're in court proceedings. So if you have to file the mortgage valuation, I presume you mean your mortgage capacity report, which the court would have asked you for, then generally it would tell you if you are self-representing, please post these documents to the court. So usually when you're self-representing, they prefer you to post it. I don't know why, because it's a waste of paper. You can ask the courts if it's not specified in your court order how they want to receive them. If they say by email, you can email them. Some people email and post it, but usually on your documents it says to post them. Okay, so I'm going to look at the last question. My husband is likely to request 50-50, just not to pay maintenance. Whereas I will buy everything clothes, holidays, as I am home with them, mainly looking after them, most of this responsibility. How do I deal with this? So I think you're saying your husband will likely want 50-50 arrangement for the children. So there is no non-resident parent. You're both resident parents. And this is done just so that he doesn't have to pay maintenance. If that is the case, then you don't have to buy everything. You buy some clothes and he would have to buy some clothes that work for his house. Because if the children don't take clothes with them, they've just got the clothes they're wearing, he would need to have clothes at his house for half the time. If there are clubs, you have to, and he will not agree to go halves with you on, say, extracurricular activities, then you either decide to make payments for them, or the children can't go if you can't afford it. So those things are extra. So it does make it difficult. Is the maintenance order for only 1 year? How can you make this ongoing? It depends how you mean. If you're talking about a maintenance agreement that you've reached yourselves, because your arrangement is not 50-50, then that can stop at any time that person decides to stop paying, and you would need to make a CMS application. Once you've made a CMS application, then that's ongoing. That will keep going until the CMS assess the person again, usually yearly, and they will make another calculation. If the person doesn't pay, they will enforce it. If you don't want to make a CMS application, or you do make an application and you don't want to collect it via CMS, and you put it in the court order only, so you've got an agreement between you, you put it in the court order saying that child maintenance will be payable at, say, £500 a month, then later on, if you say, well, it's in the court order, I want to enforce it, I want to take you to court because you're not paying it, you can't do that after a year. So the best thing to do is have a CMS application running that they have calculated it. You put that amount in the court order so the judge is aware of how much that is. If they don't pay it, the CMS will enforce it. So that's the best way of getting around it. So I hope that was helpful. I know we've gone quite a lot over time, but there was a few questions there that I wanted to answer. So I hope that was useful. Do let me know in the chat box if that was. And I know some of you had to drop off because it did go a bit over time. Let me know, was that helpful for you? Did that answer some of your questions around maintenance? I hope it did. You can always touch base with me on Instagram, Facebook, email. You've got the details there. So do touch base if you need to. Things you needed to know, yes, always. There will be a replay, so if you want to watch it back, we'll be sending out a replay as well. So look out for that, usually on Thursday. So look out for that as well. Brilliant. Well, you take care. Have a good rest of the day, and I will catch up with you very soon. Take care.